I first met Adam actually several years ago now. I heard him speak at an FPA meeting and really liked what he had to say. Thought he had a very impressive resume and a good perspective on things. But I didn't have an opportunity to work with him until recently when George and I picked up a new client that had just inherited a substantial amount of money from her father, but also had a huge amount of student loan debt. So recognizing that I don't work in this space every day, I knew that I needed some help and gave Adam a call. He was willing to jump in, and really, I was very impressed by how quickly he diagnosed the situation and made very effective recommendations for this particular client. So I thought that, with all the other advisors on the line this morning, I thought Adam would have some interesting perspective to offer. So Adam, thanks again for joining us. The floor is yours.
All right, thanks very much. So yeah, I guess I'll start. I think we want this to be more of a conversation, but I will kind of just start with an overview of what I do, how I help clients, and then I'm happy to just kind of, do a Q&A type of discussion. I'm an attorney. I'm a solo practitioner. I'm based here in Boston. Licensed in Massachusetts and New York. My practice is 100% devoted to helping student loan borrowers and their families. And so that involves a number of things. I think it's easiest for me to describe clients in sort of three very broad categories or pools. The type of client that probably most of you will encounter are this first kind, just folks who have student loans and they want some assistance in navigating the system. What are the options? Should they be in this payment plan or that payment plan? Should they consolidate or refinance? Are they eligible for any loan forgiveness programs? Do we have to change anything to make them eligible? Is it a beneficial program? Basically counseling and advice on their options, giving recommendations on a repayment approach, and in some cases helping them then implement those recommendations. Second category of clients are folks who have some sort of identifiable problem or dispute. Maybe they applied for a certain, payment program, they were improperly denied. Maybe they have, made, 7 years of progress towards public service loan forgiveness, but their servicer says they just made a year. Maybe there was an error with consolidation, or there was negative credit reporting that shouldn't have been reported that way to the credit bureaus. So whatever those issues are, I help people navigate that as well, give them some advice and direction on next steps. In some cases, I help them through a dispute process as well. And then the third category of folks are people who have, they're in trouble or they're in distress of some kind. So they're struggling with their payments, or they're falling behind, or they're already in default. Maybe they're in collections, their wages are being garnished, or perhaps they're being sued by their lender in court. So I defend those folks and help them resolve their issues there. For federal student loans, there are statutory programs that can allow borrowers to cure a default. So I help people navigate that those programs as well. Often what I do is start with a substantive consultation with folks. This is what Al was referring to, where we'll sit down for an hour. It's a substantive consultation. I do charge a fee, but we'll sit down for an hour. We'll go through everything together. I'll give you my thoughts, recommendations, strategies, and next steps. I'll write that up in a formal summary after the session is over. And sometimes that's all people need. Sometimes they'll come back to me a year or 2 or 3 later, if there's a change circumstances, that plan was based on me having this job, I lost that job, or now I got married, or now I got divorced. How does that change my repayment approach? Other times it's a more sustained representation. Maybe they want me on retainer to answer questions as needed, or if we're going to do something more involved, like getting someone out of default or defending a suit or going through a dispute process, they might need ongoing representation for that. That's pretty much what I do. I primarily take clients in Massachusetts and New York where I'm licensed. I can sometimes take clients on out of state, but it depends on the specifics. Every state has its own rules about what out-of-state attorneys can do. In many states, I can provide general advice and counsel on federal law issues without running afoul of ethics rules. For issues involving default or private loans, I'm a lot more limited in my ability to take a client who lives out of state. And in some states, the rules are so strict that I don't take any clients from those states. So Texas is one of them. New Jersey is one of them. So it really does depend on exactly what's going on. But generally speaking, Mass and New York are no issues. Any clients outside of those states, it just requires a little bit more information to figure out if it's something I can help with. So I guess I'll say a couple of things about the current state of affairs with student loans, and then I'm happy to just open it up to questions. Right now, most but not all federal student loans are suspended under the CARES Act. The CARES Act froze all payments, all interest, and all collections or government-held federal student loans, which is the majority of student loans out there, but not all of those loans. There are federal loans that are commercially issued. Those aren't covered. There are Perkins loans issued by schools. Those aren't covered. And there are purely private loans that are also not covered. So there are plenty of loans out there that aren't covered at all. But for many borrowers, they have currently nothing due and no interest accruing on their federal student loans. That is scheduled to end September 30th. I have no idea whether that's going to be extended or not. The House passed a bill that would extend those protections for another year and also expand those protections to include some other types of loans. That was passed by the House. The Senate leaders have basically said that's dead on arrival. They have pushed their own bill, which, not to get too much into politics, but it really wouldn't provide any new relief for borrowers. And the CARES Act would effectively expire, but that bill isn't even supported by, it sounds like it's not supported by many in the Senate. So it's unclear if there's going to be some sort of compromise legislation. I know Congress is currently working on that. The Trump administration has suggested that perhaps they could take executive action to extend the CARES Act relief after it expires, but we've gotten no further details and no firm commitment on that either. So as of right now, we should expect that borrowers will be re-entering repayment after September 30th, but there's still, some time for Congress to hash out some sort of relief that maybe could extend that, into the new year. So that's where things are.
Adam, I'll ask the first question here because I'm curious.
Sure.
You mentioned something about student loan servicers.
Mm-hmm.
And obviously, a lot of the viability of some of these loan forgiveness plans really depends on keeping accurate records and making sure that they agree with what your loan servicer is providing. What's been your experience with the servicers? Are some better than others? Are some more difficult to deal with than others?
I mean, I've had problems with all servicers, and in most cases, you don't get to choose your servicer. So it's not like you really have an ability to just kind of change if you're unhappy. My general view is, retain records, but also make sure that you and your clients understand the programs that you're trying for, because you can't always rely on the servicer to provide complete or accurate information about your loan history, about your eligibility for something. Sometimes they're right. I mean, I've gotten very helpful folks, but sometimes they completely steer people in the wrong direction, and that actually has been the basis of several recent lawsuits against servicers. In terms of who's my favorite, I mean, I don't really like any of them. For folks, for instance, on the public service loan forgiveness track, there's one servicer that handles that program, Fed Loan Servicing. You're stuck with them. You really don't have a choice. In terms of formal, complaints, a couple servicers have comparatively fewer complaints than others. Nelnet and Great Lakes are two servicers that tend to have fewer complaints, but they're not perfect. They've both done some pretty high-profile mess-ups themselves. The Department of Ed has indicated that in the next round of servicing contracts, they may cut out Nelnet and Great Lakes from the Department of Ed servicing system. So even if you want to go with them, you may not be able to stay with them. So it's a long answer, but the short answer is no, I don't have a favorite, but people don't really have a huge choice anyway.
Okay.
So question.
Yeah.
So the forgiveness aspect, is that loan servicing provider specific, or is that the field that the participant is in, or a little of both?
Yeah, so there's multiple loan forgiveness programs. There are some there are some programs that are just tied to the repayment plan that the borrower is in. So for instance, there's a type of repayment plan for federal student loans that we call income-driven repayment, where you pay based on a percentage of your income, and then that gets recalculated annually. And regardless of what you're doing for work or anything, any remaining balance can be forgiven after 20 or 25 years under that plan, depending on which particular plan for, based on income that you're in. Under current law, that could be treated as taxable income, however. There are profession-based loan forgiveness programs as well. There's teacher loan forgiveness, which can provide a fixed amount of debt cancellation based on, teaching in certain subjects in low-income schools. And then there's a broader public service loan forgiveness program for folks working full-time for a nonprofit organization or a public or government entity of some kind. So for instance, a public hospital or a nonprofit hospital, public school, college, university, charitable group, that can provide loan forgiveness after 10 years of payments under certain types of payment plans. All of these programs, though, are rooted in federal statute, and the servicer has no bearing on eligibility. The servicer is simply a contractor for the Department of Education or for another federal lender. They're not actually the owner of the loan, and it doesn't matter who your servicer is in terms of eligibility for forgiveness. Now, that being said, for instance, for the public service loan forgiveness program, there is by way of background, the Department of Ed utilizes several companies to service their sprawling portfolio of loans. But they have contracted one specific servicer to handle, for instance, the public service loan forgiveness program. And so what that effectively means is that when borrowers submit paperwork regarding that program, they may just be transferred over to that servicer because that servicer handles that program. But if you're with a different servicer, it doesn't mean you're not eligible for that program, if that makes sense.
Thank you.
Is the military considered part of that public service loan forgiveness?
The military is, yes. The military is a government entity. So if you're a full-time employee of the military, full-time service member, that would qualify, yes. Being in the military, yeah.
Go ahead.
Being in the military can also have some additional benefits as well. If you're serving in active duty, in particular in hostile areas, you might get some added benefits. There's additional deferment options. There's more flexibility regarding recertifications of income-driven plans. And there's an interest rate cap under the Service Members Civil Relief Act, which caps interest rates at 6% if you're serving in active duty in certain cases as well.
Okay. All right, so there's also an income-driven plan based on your rank, too.
Not based on rank. Income-driven plan is based purely on income. Now, obviously, income is tied to rank, but income-driven repayment is available for most federal student loan borrowers, regardless of whether you're working even in public service. You could be working in the private sector and still be on income-driven repayment. But for many of these loan forgiveness programs, such as public service loan forgiveness, you have to specifically be in income-driven repayment as well.
Okay, and that's a 10-year one for the military, too.
The public service program it's talked about as a 10-year program, but really it's 120 qualifying payments. You have to make payments on direct federal loans, which is a type of federal loans. Not all federal loans qualify. Right. Those payments have to be specifically made under an income-driven plan. And you have to be doing that while you're working full-time for a qualifying employer, a government or nonprofit. You do that in a single month. That's one qualifying payment. You do that 120 times. You can get tax-free loan forgiveness under public service loan forgiveness. But I just want to make sure, because there's some nuance here. It's talked about as a 10-year plan, but those 120 payments don't have to be consecutive. So it could take longer than 10 years if the payments are not made on a consecutive basis, which is fine.
Yeah. Well, with the 6-month hiatus, that's going to add 6 months at the tail end of everything.
No, actually. So if you're referring to the CARES Act, so this is why I have a job doing this, because it's so ridiculously confusing. Generally speaking, being in some sort of suspended payment status, like a forbearance, does not count towards loan forgiveness. You have to be in repayment, making payments under one of these plans. But the CARES Act created an exception to that, where if you were in income-driven repayment when the CARES Act went into effect, and you continue to work in qualifying employment during the 6-month suspension period, those months would still count towards the 120 payments as if you were making payments, even if no payments are actually made. That's the exception, not the rule. But borrowers who continue to work in qualifying employment during the CARES Act direct forbearance should wind up still getting credit for those months towards loan forgiveness.
Okay, good. Thank you.
Yeah.
I've got a question.
Sure.
It has to do with people refinancing, because sometimes interest rates drop down and they refinance off of one plan into another. What are some of those pitfalls that people need to watch out for?
Yeah, so first of all, I think it's important to draw a line between the federal loan program and everything else, which we refer to as private loans. Currently, under federal law, there is no mechanism to change your interest rate within the federal system. Your federal loan interest rate was set when you took out the loan, likely set by Congress, and it's in most cases fixed at that rate, although some older federal loans are variable. But you can't change your interest rate on the federal loan that you already have. There is a federal consolidation program that allows you to consolidate your loans within the federal system, but that type of loan is interest neutral. The interest rate for the consolidation loan would be the weighted average of the loans that are being included in the consolidation. So you don't get an interest benefit, you don't get an interest penalty either. Now, there are private loan products out there that allow you to refinance loans, whether it's federal loans or existing private loans, into a new private loan that can function as both a refinancing and a consolidation. And in some cases, yes, that can result in a lower interest rate, and that can be the primary reason for doing that. However, if you refinance a federal loan via a private loan to get a lower rate, you are forever walking away from the federal loan system and all the programs and benefits that are associated with the federal loan system. So that includes programs like income-driven repayment, loan forgiveness, including public service loan forgiveness. It also includes benefits and protections that hopefully folks will never need, but they often do. For instance, default resolution. If something happens to you, you miss your payments, you default on the loan. Federal law does provide for options for curing that default and restoring the loan to good standing. That doesn't really exist in most cases for private loans. There also are tax-free discharges for federal loans based on the death of the borrower or disability of the borrower. If the borrower becomes injured or sick and can't work anymore, there's a tax-free discharge option available for federal student loan borrowers.
Wow.
That may or may not exist for private loans, but if it does exist, it's definitely not going to be as strong of a program or strong of a protection as the federal loan system is. So long answer to your question, but basically, if you're refinancing existing private loans into a new private loan to get a lower interest rate, I think there's generally nothing wrong with that, as long as the new loan product is comparatively better than what you started with. For federal student loan refinancing via a private loan, I think it's you have to be a lot more cautious, because once you go that route, you can't get back into the federal system. So you've closed the door on all those options and programs. So you really gotta, counsel folks, I think, on the implications of that. Even if you get a lower rate, is it worth giving up income-driven repayment and all these other possible benefits? I often recommend that if folks are going to go that route, they mitigate the additional risks of carrying a private loan by taking out additional disability insurance, additional life insurance, and having a more robust emergency fund to cover times of economic hardship, because you're just not going to have the same type of options that you would otherwise have if you kept it federal.
Great, thank you.
Yeah. Other questions?
I have a question. As far as the public service loan forgiveness plan, is there, we've been hearing a lot that married individuals, that if one spouse qualifies, they should be filing separately. Is that really a true statement?
So it's a little complicated. So let me first kind of review the program and how it works. So the key elements of the public service program is you have to have direct federal loans, which is a type of federal loan. You have to be in repayment under an income-driven repayment plan, and you have to be working full-time in qualifying employment. Now, as a whole, the public service loan forgiveness program does not care whether you're married or single or anything like that, because you just have to be in an income-driven plan. Now, under the income-driven repayment plans, you have different treatments of married couples. Income-driven repayment, or IDR, is really an umbrella term that we use to describe a collection of plans that are based on your income. There's about 4 different plans that are under that IDR umbrella. There's income contingent repayment, which we call ICR. There's income-based repayment, we call that IBR. There's pay-as-you-earn, PAYE, And then there's revised pay-as-you-earn, REPAYE, or repay for short. They're all different. Different loans are eligible for different plans. Happy to get into that. They all use somewhat of a different formula. In general, most of the plans, ICR, IBR, and pay-as-you-earn, will factor in the combined income of married borrowers if you are filing taxes jointly. But those three plans will only factor in the borrower's income if you file taxes married filing separately. So there is a mechanism to exclude your spouse's income by filing separately. But filing separately can have tax consequences in cases where both the borrower or both people in the marriage have major federal student loan debt balances. The income-driven plans will also factor in their respective balances, and so there might not be much of a benefit to filing separately. Usually filing separately is beneficial where the borrower has high federal student loans and relatively low income compared to the spouse who has maybe no or few federal student loans and much higher income, because getting rid of that income from being factored in would result in a much lower payment. The revised pay-as-you-earn plan will factor in combined income of married borrowers no matter how you file. So this is a lot of information. I don't expect you all to kind of, really come away with it with a full understanding of this because it's super complicated. But here's, I think, the big takeaway. Not everyone is eligible for every plan. So for instance, the pay-as-you-earn plan has very strict eligibility about the dates that you took out your loans. ICR isn't going to make sense for most borrowers except for certain parent plus borrowers. So if there's a large subset of borrowers where the choice is going to be between IBR and revised pay-as-you-earn. IBR is the more expensive plan compared to revised pay-as-you-earn, but allows borrowers to exclude their spouse's income by filing separately. Revised pay-as-you-earn does not. So for a lot of folks, it's an analysis. What are your payments based on joint income under revised pay-as-you-earn versus what is your payment married filing separately under the comparatively more expensive plan IBR, and factor in those tax consequences of filing separately as well, because even if you get a lower payment, if you pay more in taxes and it completely offsets those savings, there's no point. So it really comes down to what plan you're in. Just to be clear, any of those plans qualify for public service loan forgiveness because they're all under that income-driven repayment plan umbrella, but you really got to figure out which plan is best for the borrower and how different tax filing status for married folks will impact what those payments will be.
You have a problem working with clients in Connecticut?
If it's federal loans, generally no. Again, if it's just counseling on these types of programs that we're talking about, that should be fine. If it involves private loans or situations of default, I may not be able to assist. But if it's federal loan programs, that's something I generally can provide counsel on in Connecticut, yes.
Okay.
One thing I will add as well, by the way, this kind of just came up in my head. So I mentioned that the months of suspended payments under the CARES Act will still count towards the public service loan forgiveness program. Income-driven plans also have their own loan forgiveness provisions. Regardless of what you're doing for work, 20 or 25 years later, any balance is forgiven if you remain in income-driven plans. That can be treated as taxable income, like I said. But just like with the public service loan forgiveness program, the CARES Act forbearance will still count towards those 20 or 25 years, even if no payments are made. I want to add another thing about income-driven repayment, because this is often where I recommend that folks talk to their financial advisor. There's no requirement under income-driven repayment that the payments be high enough to cover the monthly interest accrual. So there can be situations, and this is pretty common for folks with very large, very high federal loan balances, that your monthly payment that's calculated based on the formula could be less than the amount of monthly interest that accrues, and as a result, your loan is negatively amortizing. You are making payments, your loan is in good standing, you're making progress towards eventual loan forgiveness, whether that's the 10 years, through public service, or whether that's the 20 or 25 years under, the normal income-driven plan thresholds. So you're doing everything right, and yet your balance is growing. That can be particularly concerning because while public service loan forgiveness is a tax-free form of loan forgiveness, another benefit of that program, under current law, the eventual forgiven balance on the 20 to 25-year terms could be treated as taxable income. And if that balance is growing and that gets taxed as income in 2 decades, that could be a pretty hefty tax bump. Now, Congress may pass a legislative fix at some point to exempt that from taxation. We have insolvency as an existing exemption under the tax code. But my view is always, hope for the best, but plan for the worst. So I often recommend that, rather than just throwing extra money at the loan, which you can do, but you can't get that money back if, Congress passes a fix, say, to exempt this type of loan forgiveness from taxation. I often recommend folks consult with a financial planner or advisor to set up some sort of long-term investment fund that's going to serve as a risk mitigation vehicle, so that if Congress doesn't pass a fix, if you don't qualify, say, for the insolvency exemption, or if you change your goals 15 years in and you want to just pay down the loan, you have something that you can tap into to either cover it or mitigate the cost to you. And that's something that I often recommend that my clients talk to a financial planner to kind of, figure out what that looks like in terms of the appropriate fund and the monthly contribution. And again, I think that's generally a better route than just paying extra on the loans, because if the goal is loan forgiveness as opposed to loan payoff, there's just not a huge incentive to pay more than you need to if you're going to derive a pretty substantial loan forgiveness benefit at the end. Whereas for private loans, for instance, which aren't eligible for loan forgiveness, we just want to pay those off as aggressively as possible, whether that involves refinancing or not. Paying extra can go a long way, obviously, to saving on interest in the long run.
I got a two-part question.
Okay.
Part one is, what do you see we'll say the client situation that you feel is where you can best help that client? That's part one. Part two is, how do you charge?
Sure. So I would say, an ideal client is one that fits in one of the three buckets that I referenced at the beginning. Either they just need some counseling on their options, they've got a problem that they want help navigating, or they're in trouble and they need some defending. Ideally, they live in New York or in Massachusetts. If it's not quite in one of those buckets, or they live in a different state, it doesn't mean I absolutely can't help them. It's just I need a lot more information to determine if it's something that I can really help with. But an ideal client, one of my favorite types of clients to work with are probably the types of people that you would encounter, folks who, doctors, lawyers, and other professionals who, have, quite a bit of student loan debt, and they're just trying to figure out what's the best way of tackling this. I love solving those types of problems. I'll run the numbers with them. We'll do different scenarios, and I'll be able to help them figure out, do we do income-driven repayment? Do we refinance? Do we just pay it off as aggressively as you can? I like that type of analysis. In terms of how I charge, so I mentioned, I think at the beginning, that I usually start with a consultation session. Al recently participated in one of those with me, with one of his clients. It's usually an hour session. It's all virtual now. And we'll go over all of this in real time, and I'll follow that up with a written summary of what we talked about as well. I typically charge $350 for the hour, and that includes the write-up. That's also my normal hourly rate if someone does decide to retain me, for ongoing assistance or representation after. I do charge some sort of retainer, but that could be anywhere from a couple billable hours if it's a fairly straightforward project. That'll be a lot more if it's something more complex, like I'm defending a collections lawsuit or something like that. So we would figure that out in terms of what that looks like. But $350 is my normal hourly rate. It's also my consultation rate. Sometimes folks have a very discrete, concise problem. They just have a couple questions on, say, what's the best way of completing this form? Or they have, 5 questions they just want to go over with me. It's very targeted. In those types of situations, we might do a shorter consultation session for a prorated fee, say 30 minutes for $180 or something like that. But usually we do the full hour if it's a more open-ended type of discussion.
Thank you.
Yep. Happy to take another question or two if anyone has.
What do you see coming down the pike in terms of reform over this area?
It's an excellent question and an excellent time to ask that question. Who knows? I've been doing this now for almost 10 years, about 9.5 years at this point. And, it's been interesting to see the conversation evolve over that time. I think we are at an inflection point right now where, there's $1.6 trillion in student loan debt. The cost of education is insanely high. And 40 million Americans are struggling with this debt, and it's becoming increasingly difficult to repay. A lot of the programs that have been set up to help to help people have more manageable loan situations are poorly administered and rather messy, and of course confusing for many people to understand how to navigate it. So, I mean, I think the system is not in a great place, and I think there's general bipartisan agreement that something needs to change. Of course, what does that something look like? I don't foresee any major changes through the end of the year. The House Democrats passed a stimulus bill that would extend the CARES Act relief by another year and would provide targeted $10,000 in student loan relief to the most economically distressed borrowers. The Senate basically said that's dead on arrival. The Senate passed something that doesn't really do anything for student loan borrowers. Or they didn't pass it, they proposed something. The House is definitely not going to pass that. I don't see anything other than possibly a modified extension of the CARES Act passing, before the election. I think that, we're looking at, in the best case scenario, maybe 3 or 6 months of additional CARES Act relief. At best, I think that's the more realistic scenario. The outcome of the election, I think, will be largely, determinative as to what else we might see. There's plenty of, bills out there, both on the Republican and the Democratic side, that would in some way change the system. So I think there's bipartisan appetite for some reform, but I don't think, next year there's going to be a bill passed that wipes out everyone's student loan debt. I think that is not particularly likely, but I think it's possible we could see some targeted loan forgiveness. We could see a loosening of bankruptcy restrictions. We could see a simplification of the repayment plan programs, greater accountability, things like that, I think, are the more likely type of reforms that we'll see.
Thanks.
Mm-hmm. Any other questions?
Adam, thanks so much for taking the time to spend with us today.
Yeah.
Very informative.
My pleasure. Thanks for having me.
Thank you so much, Adam. It's been great.
Likewise. All right, take care. And feel free to reach out if you all have any other questions.
Wonderful. I'll share your information.
Thank you very much. All right, bye-bye.